Thank you for joining us today for our Grand Round session. We're going to be discussing the ins and outs of advanced directives, legal and medical perspectives. My name is Kathy Carnino, and I'll be the facilitator for today's session. It's my pleasure to introduce today's speakers. Dr. Guernsey is a Springfield native, a 2006 graduate of the School of Medicine, and a 2009 graduate of SIU's Internal Medicine Residency Program. After completing residency, he joined SIU's faculty in 2009 as a hospitalist, a clinical role that he still maintains. His current academic rank is associate professor. He was promoted to division chief of general internal medicine and departmental vice chair of hospital medicine in 2020. He has participated in numerous projects and committees at SIU, Memorial, and St. John's, and he also currently holds a medical director advisory role in the Office of Correctional Medicine. Paulette Dove serves as senior counsel for health affairs at the School of Medicine. Prior to joining SIU, Paulette worked with physicians, medical providers, regulators, and insurers in a variety of settings. Most recently, Paulette worked for the Illinois Department of Insurance as general counsel and deputy director of health products, and for the Department on Aging as deputy general counsel. Before joining the state, Paulette established the legal team for a rapidly growing physician group and also spent 15 years in private practice. During her time in private practice, Paulette represented physicians, nursing homes, insurance companies, and litigated complex civil matters. Paulette graduated from Washington University College of Law at the American University, and she completed her undergraduate work at the State University of New York at Albany. Please welcome Dr. Guernsey and Paulette.
Thank you. So clearly I need to shorten my biography. Kathy, remind me of that next time. Dr. Guernsey and we think back by popular demand, but we're not sure about the demand. How many of you were here the last time Dr. Guernsey and I presented? So just a couple of you, okay. Make sure you ask questions as we go through this. We want to get to the information that is helpful to you. And especially if you've heard some of this before, don't hesitate to jump in if we forget to say something or there's something that you want to get clarified. So we have some objectives for our conversation today. We're going to define what advanced directives really are in Illinois. We're going to talk about the legal ramifications of the different types and also the medical utility or the practical application of these different kinds of legal documents as we go through this. And as you heard, Dr. Guernsey is the one who's literally on the ground working with patients and their families and who are in these difficult situations often and need somebody to help make their healthcare decisions. I'm the one that sits over in the office when it's all calm and says, oh, this is how you do it. So, so that's why we're your tag team. We've got calm and we've got real life. So really, what are we going to talk about? What is an advanced directive? It is direction that somebody gives you in advance of when they need it. So before the crisis happens, when they are able to calmly think about what their healthcare requests might be in the future. So you don't want to wait until you're in the emergency room after an accident and have to decide, oh, can my friend, my neighbor help make decisions? This is something today, you know, when you go back to your offices or this evening when you're at home that you want to think about in advance and figure out how to put those, your directives or your guidance in the right kind of legal document that will be recognized in Illinois by your healthcare providers. There are several types of advanced directives that are available and recognized in Illinois, and so they're listed here for you, and we're going to talk about each of them in a little bit more detail. So, as I said, the key here is that you're looking at something in advance when you don't think you need it, right? It's all we all are thinking that bad things happen to other people, right? And that's not true. Could happen to anybody. And so think about it now. Think about it with your children and your family members. This is just my little bit of reminder so that Dr. Guernsey's life is easier when you show up in the hospital or in his office. from a legal standpoint, so my recommendation is that everybody age 18 and over should have a healthcare power of attorney. Also property power of attorney, but that's not what we're here to talk about today. So those of you who were here before have heard that I've got 3 children. 2 of them are over the age of 18. For their 18th birthday, they each got a copy of the standard Illinois recognized form, power of attorney for healthcare. We had it witnessed, it was signed. You bet they named mom and dad as their powers of attorney. And I know that may sound a little bit extreme, but those 2 kids are away at college. Either one of them could be in an accident or something like that. I want to call the hospital, and one of them is in another state, and be able to have a conversation with their healthcare provider and get information. And so this document that I keep in a certain binder in our kitchen, I've given it to their primary care providers here in Springfield. For the one of them that's had some procedures at one of the local hospitals, it's on file at the hospital here. And it really suggests that that is the best thing to do. We have a form that the Illinois legislature has approved. It's not required to be used, but it's a really easy, straightforward way to enter that healthcare power of attorney. From a legal standpoint, the Illinois Department of Public Health governs the publication of that form. So they are required by statute to publish it in English and in Spanish. They do have available in other languages on their website, but I don't think they're required to do that at this point. So that's where you go for the most current form. Certainly if you're working with an attorney to do a will or something like that, they will help you with the process. But you don't need to, this is probably the one document I will say that you don't need to be in front of an attorney, because Illinois has this really good form for you. And the form, if it's valid in Illinois, almost every other state will recognize it when you're in those other states. Same thing for us here. If it was valid in Iowa when the person executed it, we will recognize it in Illinois. So if somebody's visiting or moves here, they don't have to do a new one. And you want to think about, what kind of direction do you want to give? I want to see if our next slide, I apologize. Okay, so before we get to the type of direction, Dr. Guernsey is going to share with you some of the recommendations from a medical perspective of what healthcare providers would like to see you put in that form when you execute it. Is that okay?
Yes.
Okay.
All right. Can you hear me okay? Wonderful. Thank you, Paulette. So as the slide says, if possible, list specific requests or scenarios on these advanced directive forms. It makes it a lot easier for your family members and for your healthcare providers to do what you wish in those situations. So you can talk about chest compressions or CPR. You can talk about artificial nutrition or not. You can talk about breathing tubes, being on the ventilator. You could talk about if you want to be on dialysis or not. If you kind of think of the debilitating medical scenarios that patients may get themselves into, if you have preconceived thoughts about whether or not you want to go through those, please list those preferences. It's a lot easier for me as a healthcare provider if the family member thinks that they are just vocalizing that patient's decision instead of feeling that they have to make the decision themselves. All right.
Yeah, and so I would just want to quickly add the one thing also to think about is when you want it to be effective. So the normal form asks you if you want it effective now, if you want it effective when your provider decides that you can't make your own decisions. Sometimes whether you can or can't make your own decisions becomes a topic of debate in the medical field. So if you are naming somebody that you completely trust, what I have done on my own is made it effective immediately. So that doesn't take away my decision to make my rights to make my own decisions, but it takes away any potential conflict where one doctor might think I have the capacity and one might not think that. my healthcare power of attorney is still going to be able to speak. And so that's one of the important things, in addition to the details of the medical care, who you choose and when it's effective for them to start making decisions.
Wonderful. And a great segue into the first line that we have to cross when getting these documents filled out, and that is decision-making capacity. The patient has to have decision-making capacity to initiate or to initially sign one of these documents. And then, as Paulette alluded to, the time that one of these documents becomes effective is when the patient no longer has decision-making capacity. I will often have scenarios where a family member expects me to come to them for every decisions because they are the healthcare power of attorney. But the reality is that my patient still has decision-making capacity, so the power of attorney is not effective at that time. So let's talk about decision-making capacity. The number one thing is that this assessment can be done by any healthcare provider, okay? Residents, MDs, DOs, nurse practitioners, PAs of any specialty. I've seen times where someone wants a psychiatry consult to assess decision-making capacity. That's an unnecessary use of their time. We'll put it that way. Please also note that decision-making capacity is time and situation or question specific. So I could have decision-making capacity right now about one aspect of my healthcare and not about another. An hour from now, I may lose the decision-making capacity about the first aspect. So it's time and situation specific. It's not affiliated with orientation. So patients with dementia, other neurologic conditions that are not oriented to person, place, and time can still have a conversation with you and exhibit decision-making capacity about a condition. Likewise, you could be fully oriented, know where you are, know the year, and not be able to tell me your risk benefits and alternatives of making those decisions. And then the last point about decision-making capacity, it is not the same as making a good decision. I tell people all the time that bad decisions are my job security. If people made good decisions, many of them would not be in the hospital or have the chronic conditions that they do have. So patients are allowed to make bad decisions if they can voice to you the risks involved with making those decisions. All right, now we're going to get into some types of advanced directives. First one we're going to talk about is power of attorney for healthcare. This is luckily the most common one, luckily for Paulette and I, the most common one used and the most useful. As Paulette mentioned, Illinois has a statutory form. You can also find this form on many other websites. When my older daughter turned 18, she also got this as a birthday present. We used a third-party website, paid a minimal fee, printed it out, had a friend meet me at the bank to do the notary, and we are off and running. My younger daughter turns 18 next year, and it will be part of her birthday present as well. And it's for the same reason. My older daughter goes to college out of state. If something happened down there, we needed to be able to be involved with her care. Any healthcare provider can rely on the form as it is currently presented to you. You don't have to guess if this is accurate or not. The only reason it wouldn't be accurate is if then somebody else, let's say a different family member walks in and says, no, mom redid that just last month. I'm now the POA. Okay. So we just use the most recent one. But you don't have to reconfirm it every time.
And you don't have to verify everybody's signature and things like that. If they give it to you, you get to assume that it is valid. We do have some departments who are like, well, you know, they named their son as power of attorney, but we don't think the son's doing a very good job. And I'm like, I'm sorry, but that's not, in the absence of really extreme circumstances, we have to rely on the document that we're given, and we assume everybody's signature is their signature. We are not the signature police. We're not the capacity police either. If it says it was date, if it's dated, they signed it a month prior, and you're thinking, boy, this person has really, significant Alzheimer's. They couldn't have had capacity a month ago. That's not ours to question. We can rely on that document. The law is really clear. We can rely on it. And the law is really clear that anybody over the age of 18 has capacity, unless it's determined otherwise. So our teenagers that we talk about, they are not ready to be adults when they turn 18, but the law gives them the decision-making power of adults, and so that's what we rely on.
Yep. Okay. So a little bit more about the healthcare power of attorney. As Paulette mentioned earlier, when is it effective? So you can determine when this is effective. I would second her opinion that immediately is the best way to go about this, assuming you trust the person that you've identified as your POA. And this becomes effective when the physician or the provider determines the patient doesn't have decision-making capacity. If they're available, you can check for patient preferences on this document. So things like particular life-sustaining treatments, maybe some limitations on the POA authority. So I want them to make decisions about tube feeds, but not about a ventilator or not about dialysis. So you can give limitations on their authority. It has to be signed by the patient, has to be at least one witness that's not a family member, or at least not an immediate family member. And it's in perpetuity valid until the patient revokes it. Okay. All right. We're going to move on to another type of advanced directives. We're going to talk about a living will. This is effective when the patient has a terminal, incurable, or irreversible condition, and the provider believes that death is imminent. Okay. So that means the 65-year-old patient who is diagnosed with dementia today, they have an incurable, irreversible condition, but the doctor may not think that death is imminent. The doctor may think that the patient's got another 5-10 years to live. So it's got to be both aspects of that. It can direct which procedures to use that should be withheld or withdrawn. Most of the time, patients fill out a living will when they're wanting to say that they want to die naturally. They don't want life-prolonging measures to be done. And again, it has to be signed in advance by the patient and 2 witnesses. I'm trying to think which slide. All right, we're going to go back to this living will slide. So there have been a few changes, or maybe not changes. Paulette and I are still trying to decipher this, but there was a recent Illinois law passed that tried to give clarification on a living will, or tried to give it a little bit more credence. We're not sure if it really did or not. It still says that a healthcare power of attorney is the most powerful advance directive that trumps anything else. It does maybe clarify that if a patient has a living will, that a different route of decision making cannot change that. And that would be the healthcare surrogate. So I'm gonna talk about that. So just know that living will might not be as useless as I said in round 1 of this talk.
I would say, yes,
Still
we've
is.
had many debates. So since the last time we talked to you, and this time the Illinois legislature did pass some new laws related to the efficacy of a living will. I would still say from a legal perspective, the healthcare power of attorney is the top document that is really the most important thing to have in place, primarily because the living will, again, only governs this very narrow set of circumstances about life-sustaining treatment. It wouldn't let me talk to my kids' hospital provider after they were in a car accident at college or something, whereas the power of attorney would let me do that. So that didn't change about the living will. In a somewhat circular fashion, as we talk about the healthcare surrogate and the POLST form, you'll hear us refer to the living will a little bit. The legislature, I think, circular is the best word that I can come up with. sort of said, well, if you have a living will, then maybe you don't need these other things. But if you have these other things and you do have a living will, then your other person is supposed to follow your living will. So that's as clear as it really is from a legal perspective. So
Yep.
thanks.
Very circular. All right, we're going to move on to another type. This is the POLST form. Actually think it's now provider orders for life-sustaining treatments. When the POLST form was initially developed in Illinois, only an attending physician could sign it, but now residents and advanced practice providers can also fill these out. So I think they changed the first P to provider orders for life-sustaining treatments. This is a voluntary effort. This takes the place of the old DNR form. We're going to go through a graphic of what this form looks like in the decision making. So again, it's an official state of Illinois form developed by the Illinois Department of Public Health. It's really designed for patients at the end of life or with a terminal condition, but we see it practically used in other aspects of their patient's healthcare. Either the patient or their authorized provider, so either the patient or the POA can sign this. And this can be revoked or changed anytime by the patient. So they can change their code status all they want. So it might be a little bit blurry, but this is my best attempt at getting a screenshot of what the POLST form contains. And these are the decision-making boxes of this POLST form. So I'll tell you, the top part, A, is whether or not you want CPR. So when my heart stops, do I want chest compressions or not? B is for patients not in cardiac arrest, what type of healthcare do I want? Do everything, send me to the ICU, use vasopressors. The middle box is selective treatment. So I'm okay with some antibiotics. I'm okay with some IV fluids, but I don't want big stuff. Or the last one is comfort-focused treatment. So only things that keep me comfortable, nothing to reverse a disease course that's happening. That last box becomes a sticking point for me, because if the person helping the patient fill this out doesn't explain it well enough, all patients think I want to be comfortable. And so we have patients show up to the ER or get admitted to the hospital whose POLST form looks like they essentially want to be on hospice, but the decisions they're making right then for their healthcare are different. So that's the time that we step back, we go through the form, we fill out a new one. It's usually a different box that gets checked. The blank box is if there's specific other scenarios that aren't covered under the above. And then the last section is about nutrition. So don't give me artificial nutrition at all, like tube feeds. Do it for a brief period of time to see if I get better, or I'm okay with tube feeds and a feeding tube for the rest of my life.
In that section C, sometimes you'll see if somebody, for example, has a religious reason that they don't want blood transfusions or something like that. That kind of thing might be in C, something real specific like that is a good idea to include there. And we do, I will tell you, we see some challenges to those kinds of things in reality, but be specific if you have a particular belief. For whatever reason you hold that belief, make sure you write it in there, or you have somebody write it in there.
Yep. Okay, and then I believe the next to last type of advanced directive we're going to talk about is declaration for mental health treatment. I will tell you that in over 15-year career, I've never seen this. Paulette, I don't know if you've ever seen anybody execute this either, but it is out there. And patients may show up with this, so it's important to know what it is. So this is very specific to psychiatric care, and patients can give advanced directives towards medications, ECTs, and inpatient psychiatric hospitalizations, whether they are agreeable to them or not. Like many of the other documents, it has to be signed by the patient with decision-making capacity, and you have to have witnesses. This becomes effective after 2 providers determine the patient doesn't have capacity, and this does have a time limit of only 3 years.
Yeah, I have never seen this or had somebody execute this in an outpatient space. The only time in my career, which you heard now is really long, is somebody who has had, generally speaking, inpatient admissions, who has some type of ongoing mental health issue and is able at different points to give this direction. So we don't see it on the outpatient side very often. Memorial has an inpatient psych unit. They've got an attorney who's really the expert in these kinds of things, and so I coordinate with that person. They've had some personnel changes, but coordinate with that person. So again, I don't know that you'll see this as often, but it's important to know that when it comes to mental health treatment, this declaration really trumps the other documents. If the patient has completed one of these, their power of attorney can't do anything against this document for specific mental health treatment.
Thank you. So what do we do when our patients don't show up with an advance directive? They're not able to make their own decisions, and we need somebody to help step in and make decisions for the patient. This is where we use the Illinois Healthcare Surrogate Act, and we appoint a surrogate for the patient in that moment. An alternative is a much longer process, which is a court-appointed guardian. So we're going to talk about both of those options. All right, I think, Paulette, you're going to.
Yeah. So the Illinois Healthcare Surrogate Act is really specific on when it applies and the order of who can help make your decisions. So it applies when the patient doesn't have decision-making capacity and they're having an emergency or a serious health condition. So they didn't plan in advance, right? We don't have one of those advance directives, and they're essentially in a crisis where they can't make their own decisions. That's when we get to this point. If the patient has any of the other documents that we've talked about or a guardian, we don't go down the surrogate analysis. When you get to the analysis, you've got the patient who can't make their own decisions, which means doesn't understand the benefits of the treatment and the risks if they do or don't have the treatment. The statute is pretty clear on the order of who can be the surrogate. And so we've got that listed here for you. You can see that in some of these categories, there might be more than one person. So if they've got 6 adult children, all of those adult children are at equal decision-making capacity under the Surrogacy Act, and they have to agree. You can imagine that sometimes that's not the easiest situation when the patient, when mom or dad is in crisis and facing some type of a serious or life-threatening issue. So just be aware that we as providers have an obligation to notify everybody in the category as we're going through this surrogacy list, and we have an obligation to try and follow all of their wishes or have them agree on it. There are some provisions for when they don't agree and how we can work through that, but this can create a little bit of controversy. And also, when you're using the Surrogacy Act, the patient has to be notified that you're doing it and what the surrogate's decision is. If the patient objects, you're not supposed to move forward with the treatment or the withdrawal of treatment. So we started by saying this applies when the patient doesn't have capacity to understand, but then we're saying, well, if the patient doesn't want to do it, maybe you can't move forward. So that's another way that when you get to the surrogate process, it's not as clean as some of the other things that we've talked about where there's maybe been some advanced discussion and decisions. So when we look at the healthcare surrogate, yep, go ahead.
So you may ask, like, what scenario does that play into, right? So a patient may not be able to tell me whether or not they agree to get an MRI, get a surgery, but if I mention their adult child's name, it triggers them from their subconscious, and they're like, I haven't talked to her in 20 years or something, right? So that's the way it could be both, where we need someone to help make healthcare decisions, but they can voice an opinion about who their decision maker is. It also takes that other person to agree. So we may have a spouse, we may have adult children, they all may disagree to be the decision maker. So you could get further down on this priority list because the other person has not wanted to step in and be the decision maker.
Yeah, and we do have that happen. We have had a couple of instances over the past few years where there has been an inpatient where we didn't have somebody, there was no advance directive, and we couldn't locate somebody on this order of priority list to help make decisions, and the person wasn't able to speak. And so it does happen. It's difficult. It's unfortunate. And that's when we have to move to a different process. So here we talked about some of the limitations of the healthcare surrogate. So death is imminent and they have a qualifying condition. So the patient has to be in that real narrow area. The physician and another provider have to agree on those two things. And also there are some limitations on whether the surrogate can determine care should be withdrawn. So if somebody's getting artificial nutrition, and that is the only thing preventing them from death, there's limited circumstances on when the surrogate can decide to withdraw that. Even when it's, a situation where you think, mom or dad or my friend or my child wouldn't want this to go on, the law isn't as clear on what the surrogate's power is in that situation. So it is helpful. I think you probably end up using a surrogate more often than any of the others.
Unfortunately.
Yeah. So it happens in real time. Dr. Guernsey runs through that list of priority. We have 24 hours. You're supposed to contact the people in the priority list and get them to come in and help make decisions. You can imagine when somebody comes in crisis, sometimes it's hard to just figure out who are their parents or their adult children and what are their phone numbers. How do you get in touch with them? So another reason to have some of this information on file already in advance with your providers.
I'll add a couple comments about the withdrawing care disparities. So a healthcare power of attorney can withdraw care and the providers have to abide by that. Under the Surrogate Act, the surrogate can voice that decision or that opinion. They think the patient should withdraw care. We think we should switch to hospice. But based on the second bullet point, it takes two providers to assess that patient, agree that they have a life-ending condition and death is close. So this is more of an opinion as opposed to making the full decision about it with a POA.
Okay, so guardianship. I often get a call that says, patient X has a guardian, and can I give them A, B, and C information? I say, okay, how do you know they're the guardian? Well, they told me. Okay, no, we got to see the documents. So guardianship is not an advance directive, and you can only become a guardian by court order. And that order is called letters of guardianship or letters of office, which makes no sense. But that's the document you're looking for. So when somebody tells you, I'm the guardian for Zach here and I get to make his decisions, you have to ask for the document. And somebody who is really a guardian knows they've got that document in their purse, in their glove compartment. They're used to providing that document. If they give you a hard time, they probably aren't the guardian. So just know that we need to ask for that and we need to review it. So get that over to the legal office, get that over to our privacy office. Guardians come in all shapes and sizes and with various levels of authority. A lot of guardians don't have the power to make healthcare decisions, and we need to understand that. I don't expect you guys or Dr. Guernsey in a crisis to read that and totally understand what it means. So please rely on legal, rely on privacy and compliance to help you read those. So that we know, but this is a longer process. You've got to go to court. Anybody can go to court and request guardianship. Your neighbor can go to court and ask for that. For an adult, they have to show that you're under a disability. You're not able to make your own decisions, and the judge will make that determination. For children, it is a little bit different on whether you're a legal guardian. Parents are assumed to be the legal guardian without the document. Anybody other than mom or dad needs a court order to show that they're the guardian. And I said here, ask for the document. I should have said that before. Same thing for the healthcare power of attorney. We need the document and it gets scanned into their record. Again, I would say several times a week, I get a call that says, well, their son's the power of attorney. And I say, okay, let me see the document. Well, we've been treating this person for 20 years. We don't have the document. I'm like, okay, so we get the document, son's not the power of attorney. And so then we think, what have we done now? We've got to turn this whole arrangement on its head. So ask for the document. Again, the people who have that power, who are the guardian, who are the power of attorney, they will provide it to you. And they'll understand that you need that from a legal perspective. I tell everybody legal has broad shoulders. You say, that Paulette girl says I have to have the document. So you just blame it on me, whatever works for you. So that's a little bit about guardianship. There is an office of public guardian. So when there is a patient who has truly nobody to help with their decision-making power and they are not able to make their own decisions, there is a process for a publicly appointed guardian to come in. That is really rare. You can imagine there are limited resources for that. And it takes a little while, but there is a process for it. And so sometimes I get that call from people in our clinics. They say, this person just can't understand what I'm telling them. They can't follow advice. They can't make decisions and they have nobody. What do we do? And so then, I may reach out. There's a public guardian for the county. There's a state office of public guardian, and we try to work through that. But I will tell you, in my 30 years, I've probably seen half a dozen situations where a public guardian has been appointed. It's pretty rare. And then we wanted to mention, this isn't an advanced directive, but there is a new law in Illinois, medical aid in dying. It's known as Deb's Law because one of the people who advocated for dying with dignity was named Deb. The legislature passed this in the fall of 2025, and it will become effective in September of 2026. This statute allows providers to prescribe a life-ending medication under very specific circumstances. They need very specific input. They need at least 2 affirmations from the patient that they want to do this. The patient has to have capacity. They also need a written request. The prescription is written by the provider, and then the patient can self-administer the drug. The law doesn't allow for the physician to administer the drug. So this is coming, it's coming to a neighborhood near you. We are having actually this afternoon another conversation about how our organization will support providers regarding this law. I've been in constant conversations with the attorneys at the hospitals and the Springfield Clinic on whether they're going to have some position on this, because the employer can take a position on whether or not they let the employed provider prescribe this type of a drug. So this is new. There's 10 other states, I think, that have similar laws. There is a judicial challenge going on to this right now. But so if you hear a little bit about MAID or Deb's Law, dying with dignity, that's what's going on in our community and what we're all working hard to try and find the right level of support for our providers who may be asked to prescribe these types of drugs. The other thing is that the statute on this is really clear. While we're calling it, Dr. Guernsey has put on here assisted suicide. The legislature was very clear. This is not going to be considered suicide. The cause of death for the patient has to be listed as their underlying condition. So whatever terminal condition they had, The legislature is very clear. Insurance companies and things like that can't void coverage because somebody uses this law to get a prescription to end their life. So there was a lot of thought that went into it. And again, there's a lot of guardrails. So if this is something that SIU supports, we'll have to follow those legislative guardrails very closely, and we'll help you through that process. What else on that?
I don't think we know. I think it's going to be a very tricky thing. We know that St. John's has already come out and said, or I guess HSHS as a whole organization has said that they are not going to be in support of this. They're not going to have providers do it on their property. What does that mean for one of their primary care doctors? I don't know. What does it mean if a hospitalist agrees to provide this care that I'm discharging someone from Memorial, but what's Memorial's stance on it? Do I have to go by that? Do I go by SIU's stance? I don't think we know right now. And from your more conversations, but my little bit with Memorial people, they don't know where they're going to fall in this spectrum of abiding by this. One aspect of the requirements, the patients have to live in Illinois, right? We don't want this to be a commuter medicine, like what has happened with other aspects of healthcare where people are crossing state lines to get things that aren't available in their state. So they did put that in the law. So it's going to be interesting. I was, even right before this, I was trying to figure out what are these medications, and I saw something from New Jersey, and it listed 5 meds, and they are at doses 800 to 3,000 times like a normal dose. Part of their 5 meds was morphine, 15,000 milligrams, and normal doses in hospice are 5 to 10 milligrams. So it's just, who's right? Are you comfortable even typing that number out? There's just a lot of unknown in this.
Yeah, and a pharmacist is going to have to fill that
Right.
prescription, unless our providers get some type of license to dispense it. So there are a few layers of just reality that our community, our state employees and companies have to get through before this can go into effect. If Dr. Guernsey writes the script, but there's not a pharmacy within 500 miles that'll fill it, the patient isn't going to get the relief. And so it's a little bit harder for me to have the conversation with the pharmacies. I don't have a Walgreens friend I can talk to or text at any given moment, but we're paying attention to that and also paying attention to what the Pharmacy Association is suggesting. So those are all of our prepared remarks. So now we just want to remind you, talk to your colleagues, talk to legal, talk to compliance when you have a difficult situation with a patient, a colleague, a friend. We're all here to help with that. But I don't think we can overstress the importance of thinking about this for yourself, thinking about it for your family, thinking about it. You can ask your patients about it. We don't advocate. At our federally qualified health center, they do have a legal aid lawyer who can help, but we always can give this Illinois Department of Public Health forms to patients. We can give them the healthcare power of attorney, the living will, the POLST is a form. So it's a conversation that is really important to have before you need it. You've been a pretty quiet group. Questions? What do you want to add? Somebody must have a question for us. I have to call on you. Yeah.
Attorney, you only have one person.
You can name successor people. So you generally shouldn't name 2 people because then they have to agree, right? And the law suggests don't name 2 people, but you can list successors. So you can list, I could list my son, my daughter, and then my other daughter. And it's based on their availability and their willingness. So let's say my son is number 1. I have an accident, and he's in Italy and we can't contact him. They're going to go to the next one. So you do want to name more than one person because at any given moment, the person you want might not be available. for a variety of reasons, right? It might just be they can't be contacted. You can change it at any point. I will tell you, people generally don't update these real regularly, at least in my experience, which is another reason to name successors. You know, when I did this, I had my mom and my dad. They're fortunately both still alive, but very easily I could have the first 3 people named are no longer with us, and I just didn't update the form because even lawyers aren't very good about doing this. Does that answer your question? Yep, so if none of those people are available or willing to serve, then you fall into the category of somebody who doesn't have a healthcare power of attorney. And so your document isn't helpful anymore. So then we look to the other things. We look to the living will. We may look to the surrogate act. We may have to look for a guardian, things like that. So it is helpful to take a look at that document every few years and make sure that you've got some contact information. I put a piece of paper with ours that has the phone numbers for the people right on it. The form doesn't call for you to put the phone number, but a name isn't, I mean, my name's Paulette, so a little bit unusual, but if I name John Smith as my power of attorney, how is Dr. Guernsey going to know, well, which John Smith do I call to make these decisions? So that's just another piece of it. Put their contact information right with it and update it every once in a while.
Yeah.
For example, not that they've got married or something. So you've got to think about is it easy to identify who you have on there and have other contact information might be.
Yeah, good point. So if somebody's name changes, are they the same person that you named in the power of attorney? So again, look at that and update it as you can. But if you've got the phone number and the phone number goes to Paulette, who maybe Laura named Paulette Fiorentino, that's my maiden name. Now you get Paulette Dove. It's pretty clear, same phone number and a Paulette, it's the right person. So another reason to try and clarify that for your healthcare providers in advance.
Same with like if my older boys that they'll be 19, but they have to like choose who they want.
Yep. Yes. So. Yep. So they do. The kids have to. They're adults, so they're 19. They're adults under the law, and yes, they do have to list them in order of priority. You always can pass. Let's say your mom's listed first and Dr. Guernsey calls you and you're like, I'm so emotional, I can't do this right now. You can say, I pass, call the next person, knowing it's their dad or whoever it may be. So there are ways to work through the list, but yes, the person has to make a decision on who they want to sort of be number one. And who they want to leave off the list. The other thing, I do recommend telling people that they are your healthcare power of attorney and give them a copy. So if I named Dawn as my healthcare power of attorney, but she didn't know, and Dr. Guernsey has this paperwork and calls her, she's going to be like, I have no idea what Paulette wants to do in a crisis. So talk to the person that you name. Those can be hard discussions because you're talking about the situation that you really hope never comes. I mean, we all know we're going to pass at some point, but we don't want to talk about it. At least I don't. But talk to the people that you've named or that name you so that you have some understanding of what they want and they know what you want when you get into a crisis situation.
That person decline?
They can decline. Yep. They can decline. Everybody could decline. And then you end up in that situation where, okay, so now there is nobody who's the power of attorney. Even though there's a document, if everybody has declined. Another reason to look at it, if you've named your spouse and you got divorced 8 years ago, but you didn't do a new one, they might not want to be your healthcare power of attorney. They might. I mean, we see that often, but look at that document. Your relationship may change. You may have named you're 19 and you named your best friend in college, and now you're 27 and you haven't seen each other in 5 years, right? So look at it as your life changes. Again, it is a super easy form to complete. The form is always available for free. I don't know why Dr. Guernsey paid for it. It's always available for free from the Illinois Department of Public Health. And it walks you right through it. It's got probably 3 pages of instructions, more instructions than you're going to want. So
Yeah.
One or two of the most common things you encounter as a physician when you are trying to sit through some of these things, so we can try to avoid that.
Thank you for looking out for me. Yes. A common encounter is someone doesn't have a healthcare power of attorney. So now we have to use the Surrogate Act and go through that list of prioritizations and find someone that's willing to do it. And that's a phone call out of the blue, right? And if you get way down on that list, it's like some other adult family member or a close friend or the neighbor. So you can imagine those conversations are hard where I'm waking up somebody's cousin 3 states away at midnight to here's what's going on. So not having a power of attorney, healthcare power of attorney form. A similar related is not having a copy of the form. You do have a POA, but you don't have a copy of the form. So now I still remember this was a few months ago. It took multiple people to look at this copy of a copy of a copy to try to figure out whose name, because we were told a name, we were trying to convince ourselves that was the name, that was the signature on the document. We finally got to that point, but that was pretty hard. So having copies of the POA document would help as well. Yeah.
absolutely,
Yeah.
give it to your primary care. Sometimes they'll look at you like, we don't know what to do with this. And you just tell them, put it in my chart, like put it with my paperwork. SIU knows where to put them. You know, we might have people change all the time, but they'll call me and say, what do I do? And we tell them where it goes. I also, if there's a hospital, if you go to one of the local hospitals routinely or not routinely, you have a preference, you can send it to one of them and they'll put it in your hospital chart if you have one.
Yep. At Memorial, there's a specific folder for advanced directives in the chart. So it's very easy. Once it's scanned in, it's very easy for us to find. Yeah.
Found because I feel like
Well, you're right. There's so much information that sometimes it is hard to find the right information. If Joe Bonansinga was here, he would say, Epic's going to solve that for us. Epic's going to make everything easier and perfect, right? Sorry, that's one of my kids who automatically comes through, even when they're on silent.
Oh,
So
nice.
I should have turned that off for him. So yes, in theory, if it's in your chart, they should be able to find it. It's better than not having it anywhere in your chart. But yeah, you can keep it in your glove compartment, quite frankly. You know, there's nothing wrong with that, but give it to the person who is your healthcare power of attorney. Tell them to keep it someplace safe that they can get to. You know, safe deposit box is a very bad place to keep one of these documents because you can't get to the safe deposit. Even if you have the key, you can only go, you know, 9 to 5, Monday through Friday. Don't keep it there. Keep it at home with, you know, your important documents, but someplace accessible that, you know, your neighbor could go in and get it if they needed to or something like that. So you want it to be accessible. Now, you know, we didn't mention this, but there is an allowance for an electronic version of the document now. I actually haven't done it that way, but there is now a method, and maybe next time we do this, if they invite us back, we'll be able to talk to you about how to have it on your phone so you can show them, and maybe that will help with some of the confusion on where is it and who has it. So we're getting there. Lawyers are really slow to adopt new ideas and new technology, so we'll get there.
certified. So we keep it in our glove boxes and kind of as you said, just put it on file with all the stuff. Usually we haven't run into any issues except when we were in Florida, my mom had to take it. We email it to the hospital.
Yeah. Yeah, that's a good point. If you are a guardian for a minor or an adult, you really need to keep those documents on hand with you, and especially when you travel, right? Locally, the primary care knows who you are. They know you've been taking care of this child or this adult for the past 30 years. But when you're traveling and your kid falls and gets hurt at Disney World and has to go to the emergency room, they don't know who you are. They don't know that they don't even know that you're the right person to be with the kid, right? And that is their job, to kind of ask, like, did you kidnap this kid and take him to Disney World? So, you want to keep those documents with you. Any other questions or clarifications? Thank you
Well,
for
thank you
inviting
all.
us
Yeah.
back, Kathy.
Appreciate it. Thank you, Kathy and Dawn.
Thanks to both of you guys for sharing all this wonderful information. We appreciate it. And thanks to you guys for joining us. Let us know if you have any other questions. We'll see you at the next Grand Rounds.